Stacy Cooper and Jose Alvarez from SANDAG's Regional Planning and Government Affairs teams. Today, this webinar is made possible by SANDAG's Housing Acceleration Program funded by REAP, and our HAP program allows our team to provide technical assistance to our region in the form of trainings like this, resources, legislation support, and one-on-one local staffing assistance. Today's webinar is going to be focused on Assembly Bill 130 and Senate Bill 131, covering provisions that are included in each bill and focused on CEQA reforms and housing streamlining. We have a number of folks from our consultant teams that will be presenting today. So without further ado, and to get started, I'm going to pass it over to Matt to begin.
Good morning, everyone. Thank you for joining us. I am Matt Geldman with Ascent. I'm a senior planner, and today I'm going to be facilitating and moderating our conversation on AB 130 and SB 131, CEQA reforms and housing streamlining changes. Can we go to the next slide, please? I'm going to start by introducing our primary speakers who are going to be giving us an overview of all of the changes these bills enacted. We are going to be joined by Gabrielle Janssens and Barbara Kautz from Goldfarb & Lippmann, as well as Chad Beckstrom from Ascent. Gabrielle Janssens is an attorney with Goldfarb & Lippmann. Her work focuses on assisting nonprofit housing developers and public agencies with keeping up with all the changes in housing law, among other areas of expertise in affordable housing requirements, ADUs, land use entitlements, and CEQA. Barbara Kautz is also an attorney with Goldfarb & Lippmann. Barbara practices in the area of land use, especially housing-related land use, CEQA compliance, real estate, economic development, fair housing, and affordable housing. Barbara has a lot of expertise working with public agencies, nonprofit and for-profit developers. And before becoming an attorney, Barbara worked as a planner, including as a planning director, a community development director, and she has also held the role of assistant city manager. And lastly, I have the privilege of introducing Chad Beckstrom, who is the Southern California environmental practice leader at Ascent. Chad is an experienced environmental planner and CEQA practitioner with expert knowledge in CEQA and other environmental regulatory requirements. Chad's project portfolio includes just about every discipline under CEQA: infrastructure, energy, transportation, schools, parks and recreation, habitat, and residential, commercial, and industrial development, as well as master planning projects. So we welcome all of them and look forward to hearing from our speakers today. We will also have other staff from Ascent and Carrie, Stacy, and Jose from SANDAG to answer questions as they come up through the webinar today. So thank you for joining us, Gabrielle, Barbara, and Chad. I'm also going to give you a quick overview of our program for today. After we wrap up our housekeeping, welcome, and introductions, we'll begin with a brief overview of the legislation to provide a high-level summary of some of the important context for understanding the provisions of these bills and the changes that were enacted. We will be focusing on the urban infill exemption quite a bit today, talking about the qualifying criteria and conditions, discussing the tribal consultation provisions, and discussing some of the practice implications for using this exception. We will do a similar presentation for the near-miss CEQA analysis enabled as part of SB 131. And then we will also cover some of the other CEQA updates, including the housing element rezone changes, as well as touching on the other exemptions and changes that were enacted by these bills. And then lastly, we'll wrap up with some of the changes to housing laws that also came with this, and just touching on that piece of the legislation as well. We will pause during different points of the presentation for questions and answering those as they relate to the topic we are presenting at the time. Please use the Q&A feature in Zoom. If you don't see that at the bottom of your Zoom toolbar, you may need to click on the More button to bring up the Q&A feature of Zoom. Once that's up, you can go ahead and put questions in there for us, and we'll do our best to respond to those live for as many of the questions as we can, but we will be trying to answer some of them in the chat as well. There may be points where we'll get to a discussion and have you come off of mute and turn on your camera if that's an option you're interested in. But we do have a lot to cover today, and so we want to manage our time efficiently. On the note of questions, please note that a lot of this is uncertain at this point, and we'll need time to work through how it's going to work in practice. In addition, I want to note that we're covering a lot of information, and there's a lot of details that we just can't cover today. And so we're going to do our best to answer your questions during the webinar, but note that for topics we're not able to answer in sufficient detail today, we'll be reviewing the questions we get and evaluating how we can provide additional technical assistance after the webinar as needed. So with that, I'm going to turn it over to Gabrielle to kick off our presentation.
Okay, thank you, Matt. So to start, I need to provide a disclaimer because we are attorneys and it's necessary for us to do so. So this webinar is intended as an overview of the recent legislation. We are not providing any legal advice today. Local staff should be consulting with their city attorney or their county council or other attorneys when determining the applicability and interpretation of the laws that we will be discussing today. So the AB 130 and SB 131 were part of the 2025-2026 budget trailer bills. This means that they went through a little bit of a different process than what we typically see with bills that the governor signs in the fall that go into effect the following year. As part of this, these bills were signed on June 30th of this year, and they went into effect immediately. So the laws we will be talking about today are already in effect, and these are tools that you can begin using immediately. Matt went over what we will be discussing today, so I'm not going to go through the list of items on the screen, but I will go ahead now and turn it over to my colleague, Barbara Kautz, who will dive into the details of the urban infill exemption.
So next slide. So this is a new statutory CEQA exemption for qualifying housing projects. It's not a categorical exemption like the Class 32 infill exemption, so it's not subject to the various exceptions that apply to a Class 32 exemption. But it includes all housing projects. It even covers single-family homes, although those are generally not subject to CEQA anyway. And then interesting, not only does it cover the project itself, but it covers all public improvements required for the housing project. So that's potentially an even broader exemption. Next slide. And so what qualifications does a project need to meet to qualify for the this new exemption? I would say in general, these qualifications are relatively straightforward. It needs to be a housing development project, which follows the typical definition in the Housing Accountability Act of any project that's 2/3 residential. And certain projects with more than 500 units only need to be 50% residential, but generally any housing development project from a single family home on up. The size can be up to 20 acres, but if it's a builder's remedy project, only 5 acres. For an infill site, if it was previously developed, it's with an urban use, it's considered to be an infill site. And then there are a variety of additional definitions allowing sites that are primarily surrounded by developed urban uses also to qualify. If it's within a city, it qualifies automatically. In the county, it has to be an urban area designated by the U.S. Census. And I assume the county is familiar with that. It has to be consistent with the general plan and the zoning. If the two are inconsistent, it only needs to be consistent with one. But zoning provisions often include, provisions that aren't inconsistent with the general plan, but wouldn't be included in the general plan, like setback, floor area, perhaps coverage standards. And the fact that the zoning ordinance has standards that aren't included in the general plan doesn't make them inconsistent. So generally they need to comply with both unless the two are inconsistent. The statute says specifically that a density bonus does not, density bonus and all the waivers that can be granted do not make the project inconsistent. So you can have a project that's requested many waivers, say for height or whatever, but that's considered to be consistent with the general plan and zoning if it's entitled to the waivers. For builder's remedy projects that follow the new definition of builder's remedy that was adopted January 1st, there's language in that statute that says a builder's remedy is considered, a project that meets that definition is considered to be consistent with the general plan and zoning for all purposes. So a builder's remedy project that meets that definition would also be consistent with the general plan and zoning. Next slide. The density has to be at least half of the housing element, what we're calling the default density. That's the minimum density that's necessary for the project, for a site to be considered suitable for lower income housing. So for communities of less than 25,000 in the region, the default density is 20 units an acre. And for all other jurisdictions, the default density is 30 units an acre. So the density has to be at least half of that, which would mean 10 or 15 units an acre. So I don't know how a single family home could qualify, but whatever. There can't be any transient lodging if the project is deemed complete, meaning that it filed a preliminary application after January 1st of this year. So if you have a project that's 2/3 residential that includes a hotel and filed a preliminary application before January 1st, it could theoretically qualify, but it can't qualify if the preliminary application was filed after January 1st. There can't be any demolition of historic structures, but they have to have been placed on a local, state, or national register of historic buildings before the preliminary application was filed. So let's say that there's a site with a building more than 50 years old, but it's not on a register. Regardless of whether it might be considered historic, the project can demolish this structure and still be eligible for the infill exemption. Next slide. It also has to meet certain environmental standards that are required for a project to be eligible for the SB 35 streamlined approval. So it can't be used at all in certain areas of the coastal zone. In most of the appeal areas, it can't be, the projects won't qualify. It's not allowed on prime farmland or farmland protected by a public vote. And then there's a list of various other kinds of natural features where the site can't contain: wetlands, habitat for protected species, be included in the Natural Resources Protection Plan. It is allowed, it can be used in a very high fire hazard zone, on a hazmat site, in an Alquist Priolo earthquake fault zone, or in a flood, an area designated as a flood hazard area or floodway, if the project meets the, provides evidence that it's includes the mitigation that's listed in the statute. Next slide. If the project is 100% lower income or is higher than 85 feet above grade, then it's subject to prevailing wage standards. There's also certain labor requirements that apply to the applicant as well as to the developer. If the project is within 500 feet of a freeway, it has to have certain air conditioning requirements and can't have any freeway facing balconies, but those are applied as conditions of approval. Phase 1 and Phase 2 studies are not necessarily required before approval or before the project's determined to be eligible, but there are conditions of approval that need to be applied. And then there are requirements for tribal consultation, and that's probably the most problematic part of this bill. Next slide. So what the statute says is that within 14 days of notifying the city, if the notification occurs before July 1st of 2026, the city has to notify the tribes designated by the Native American Heritage Commission as you possibly having an interest in the area of the project and ask if they want to engage in tribal consultation. There's a big issue here about when what's the trigger for the 14 days? Does the developer just say, I think I qualify, I want you to start the consultation? We're generally advising our clients to have an application form that requires the developer to provide evidence that they qualify for this exemption before the notification is sent out. But it's very unclear how this is supposed to work from the statute. Within 60 days from the formal notification, the tribes must respond. And then within 14 days of the tribal acceptance, the city or county has to initiate the consultation, which generally means, emailing the tribe and saying, let's, we want to start the consultation. The consultation is only between the city and the tribe unless the tribe approves the applicant's participation, and the applicant has to agree to certain things. So the applicant should not be sent anything unless the tribe has approved the applicant's participation. We have some cases where, one I've been involved with already, where the applicant contacted the tribe directly without the city's notice. So the applicant should be advised that if they want to participate, they need to request that of both the tribe and the city. Anyway, the consultation has to be concluded within 45 days, although tribes can request an additional 15-day extension. And then here's the really problematic problem. Within 30 days from the conclusion of the consultation, if the project qualifies for this exemption, the city has to make a decision on the project, or county. It's possible to get one extension of up to 90 days from this deadline, but that's how the statute reads. Next slide. It doesn't require that an agreement be reached. There are certain specific specific conditions listed in the statute that must be attached unless both the tribe and the project proponent agree they can be eliminated. If there's an enforceable agreement, that also has to be a condition of approval, but an enforceable agreement has to be agreed to by the tribe, the city or county, and the applicant. So what happens if the tribe requests certain monitoring and the applicant says, I don't want to agree? Well, there's no specific restrictions on applying additional conditions, even if the applicant didn't agree to them. And the statute says specifically that the city is supposed to provide deference to the tribe and their knowledge. So it kind of sounds like the tribe wins, but this is another area that's very uncertain. Next slide. And Chad, I'm going to turn it over to you now.
Yeah, thank you. So I thought I'd start by addressing some of the previous attempts at streamlining housing in comparison to AB 130. Over the years, the legislature has made several attempts at fast-tracking housing and really offering incentives to reduce CEQA reviews for qualifying projects. But I think many of these past attempts have been kind of too complex and restrictive and really fallen short of achieving some of the desired results. So for instance, a class 32 exemption is limited to sites under 5 acres within city limits. It's subject to exceptions in the CEQA guidelines in 15300.2, as Barb mentioned. You have Article 12.5 infill exemption, which is also found in the guidelines 15195. It's somewhat elusive, and I honestly can't think of a time when I've really come across its use. And maybe because this exemption is limited to 100 units on a maximum of 4 acres, there are minimum density targets. It's limited to urbanized areas. You need to be close to transit. There's strict affordability requirements and numerous land use and environmental requirements and exceptions. And then you have the community plan zoning streamlining in 15183, and I think this one's become more popular lately for projects that are consistent with the general plan and zoning, but it requires consideration of whether or not project-specific effects are peculiar to the site or not. So it necessitates a detailed analysis as part of that streamlining process. And then 15183.3 is another one that I think is rarely used due to requirements to comply with statewide standards, design standards, affordability commitments, and essentially requires a full environmental checklist anyway. That's found in Appendix N of the guidelines. And then you have SB 375, the Sustainable Communities Streamlining. It's limited to projects within transit priority areas, requires strict density requirements and numerous land use and environmental standards. And then finally, SB 35, the ministerial process, is limited to jurisdictions with insufficient RENA progress. It also includes extensive eligibility criteria, environmental considerations, affordability, and labor requirements. Next slide, please. So from a practicing environmental planner's viewpoint, AB 130 exemption really represents a rather fundamental departure from previous efforts. For one, it's a full statutory exemption. Barb mentioned this. It eliminates environmental review requirements entirely for qualifying projects, unlike some of the other streamlining processes I just mentioned. And statutory exemptions have a stronger legal foundation since they're written into the law by the legislature, while categorical exemptions can be modified more easily through the regulatory process. It also, it's more specific, narrow, and defined compared to categorical exemptions that are more general in nature. And this exemption really offers much broader applicability. It covers a much wider range of projects than some of the existing tools. For instance, it applies to site within the boundaries of an incorporated municipality or an urban area, whereas Class 32 was just within city boundaries. There are no caps on the number of units here. There's no requirement to be close to transit. It's allowed for larger sites up to 20 acres, whereas some of the other streamlining processes were limited to 4 or 5 acres. There are no affordability requirements for most projects. And as Barb mentioned, there are limited labor requirements except for certain projects that are either 100% affordable or over 85 feet tall. And I think this exemption simplifies some of the previous criteria. It eliminates many of the limiting requirements that made some of the previous exemptions impractical, such as you're no longer subject to the exceptions in the CEQA guidelines for categorical exemptions. There are less restrictive environmental criteria, and there's no need to interpret whether impacts are peculiar to the project or determine if there are unusual circumstances. Next slide. So with these changes, planners will be able to modify their practices to take advantage of the streamlining opportunities here. Most infill projects that comply with general plans or zoning that fit within the 20-acre urban setting, I think will likely now be able to be exempt from CEQA. I think we'll see fewer NEGDECs, MNDs, and EIRs, which were sometimes required when a project just narrowly missed one of the exemption requirements. And we'll talk a little bit more about that under the near miss provision later. Planning reviews can become more ministerial, with agencies limited to verifying compliance with objective design standards without maybe a full discretionary review. And with the reduced CEQA documentation requirements, processing times will likely be shortened quite a bit. So what could have taken a minimum of 6 months to a year could be shortened to a matter of weeks or a few months, depending on the tribal consultation. And then while this exemption eliminates a full CEQA environmental review, I think there's still going to be some requirement to provide documentation and to be able to substantiate your conclusions and document the consistency with the exemption qualifications. Next slide. So with these implications in mind, I wanted to offer some suggested best practices. Again, it's important to show your work and how you'd substantiate your conclusions. Although this exemption may eliminate the need for initial studies, NEGDECs, and other environmental documentation, you still should develop a systematic approach to document compliance with the exemption, including the site requirements, the project requirements, and the environmental considerations that we talked about. It's a good idea to develop a decision-making framework tool that will help you document these findings. On the next slide, we'll show you an example of something that we've created, a worksheet that we can offer you a link to download. And we highly recommend that you file a notice of exemption with the county clerk within 5 days of approval, just as you would for any other statutory or categorical exemption. And that reduces your statute of limitations on legal challenges from 6 months to 35 days. And then, of course, you want to take note of the new tribal consultation requirements and follow those timelines and procedures that Barb talked about. And then finally, we suggest maybe you invest in some training about the new criteria here, develop some standardized procedures to ensure consistent application and proper documentation of your decisions. And here's an example of a worksheet we created that goes through all the criteria, along with some helpful links that might help you document your conclusions here. And there's a link in the chat that we've just put in there, so you can download it at your leisure.
All right, thank you, Chad, and thank you, Barbara, for that overview and introduction to the urban infill exemption. I do see a few questions in the chat. A couple of them relate to topics we are going to cover in other sections as we keep going. There's one about near miss for the exception or the exemption, excuse me. So maybe we'll table that till we get through the next section of the presentation. And we also have a question about rezoning and exemptions under 15183 that might be better discussed as we keep going and get to that part on housing element rezone exemptions. There is one question that I think was answered by you, Barb, about density bonus and whether density bonus projects are consistent with the general plan under the urban infill exemption. I think you had that on your slide, and it was a pretty clear yes, that they are considered consistent, similar to how class 32 is treated, as the question kind of suggests. So any clarifying information there needed?
No, I mean, the statute's very clear that approval of a density bonus, incentives, waivers, reduced parking is not grounds for determining the project's inconsistent with the general plan zone or zoning. So.
Yep.
Similar
for
to
that.
provisions in other sections of the statutes.
All right, we did get one other question here. Wouldn't there still be a need for a developer to comply with local ordinance requirements, even if the project qualifies for the AB 130 exemption?
Yes, yeah. I mean, there was a world of planning before there was CEQA. And so yes, cities can apply their standards. I mean, I think the difference now is the number of waivers and concessions that developers request. But that aside, yes, cities can apply their standards and requirements. I think the difficulty is going to be the timing in terms of the tribal consultation and the very short shot clock once that's completed.
All right. Well, thank you for that response. Let's keep things moving for the sake of time. If anyone has any other questions as we keep going, please put them in the chat and we'll get to them when we take a break after this next section. So I think who's up next here? Gabrielle?
Yes.
All right. Take it away, please.
Okay, we could go to the next slide, please. All right. So near miss is a new-ish concept that was added by these bills. I say new-ish because people have previously done focused EIRs, so the idea of a focused EIR is not the new concept. But the way that this applies is when a project would have qualified for a statutory exemption or one of a list of categorical exemptions, and these would be categorical exemptions 1 through 5, 12, 15, 20, 27, 30, and 32. But for a single condition, so that's one condition, not 2 or 3, the project can do a focused CEQA review. That would be an initial study that either leads to a negative declaration or an EIR. The analysis would examine only the potential effects that are caused by that one condition that took the project out of the exemption. And it does not require the analysis of alternatives or growth-inducing impacts, which is a requirement of EIRs. The term condition means a physical or regulatory feature of the project or its setting or an effect on the environment caused by the project. A couple things to note is that the near-miss analysis does not apply to projects that are not similar to those in the category of exemption that it was trying to qualify for. The project is not eligible if there are 2 or more conditions that brought it outside of the exemption. Additionally, the proposed housing development project cannot include a distribution center or oil and gas infrastructure, and the proposed housing development cannot be located on natural and protected land. And I think that is all I have for this near-miss analysis, and I'll turn it back to Chad.
Okay, thank you. Yeah, so I think we wanted to talk a little bit more about these single conditions, and I like to think of these falling into a few different categories. So you could have, size and scale exceedances. For instance, with a class 3 for new small structures, maybe you exceed the unit limit by 1 or more dwelling units. Or with a class 32 infill projects, for instance, you have a site that exceeds the 5-acre maximum site size. Maybe your project doesn't meet the density requirements for certain exemptions, or perhaps your site is not sufficiently surrounded by urban development like is required under AB 130. And then you could have projects with regulatory inconsistencies, such as projects that may be inconsistent with the general plan designation or have non-conforming zoning. Perhaps your project may trigger one of the environmental thresholds, such as having sensitive biological resources or triggering one of the exceptions in 15300.2, such as having cumulative impacts, unusual circumstances, scenic highway impacts, historical resource effects, that sort of thing. And then there's some other project eligibility limitations. For instance, what if your project doesn't meet the affordability requirements or the labor standards in one of the exemptions, or you're not proximate to transit? But there are still several questions and uncertainties in my mind as to how this may be interpreted and applied. If you could go on to the next slide, please. So I think several aspects of this remain open to interpretation and will likely be clarified through practice and potentially litigation as we figure these things out. You know, there are quantitative boundaries to consider. So how far can a project exceed the exemption thresholds while still qualifying under that single condition deviation? You know, for conditions involving exemptions with caps on the number of units, is it 1 unit over? Is it 20? For caps on site areas, how much beyond that 5 acres can you exceed, for instance? Can you go up to 100 acres? I think there are some unanswered questions here. And then, you know, when you're focusing the initial study, NAGDAC, EIR on that one condition, I think some of the conditions are more straightforward to analyze, while others may not be. So if your project would trigger one of the environmental thresholds, such as impacts on a historic resource or impacts on biological resources or air quality, I think it's pretty straightforward that your focused environmental document can sort of, you know, focus on that one environmental issue, right? But how do you focus the analysis when a project triggers a size limitation, such as exceeding the unit count or the acreage, or evaluating projects that's not fully surrounded by urban development? I think that can be a tricky part of the scope of the analysis here. And then there's, you know, how will the limited review address cumulative impacts when your cumulative impact may be the disqualifying conditions, but yet cumulative impacts don't need to be evaluated under SB 131 anymore. So I think it will be really important to determine the scope of analysis for these conditions, and that may be a tricky aspect to this. Next slide. So number of possible implications and advantages, both for lead agencies and applicants from this near-miss provision. I think for agencies, it could result in more efficient use of resources. So staff time and resources can be redirected from doing a more comprehensive environmental review to more focused analysis. You can, I think this provision provides maybe a clearer decision framework. So projects that maybe fell into some gray areas will now have a more structured approach on how to handle their processing. And then by removing some barriers to viable projects, it will support local and state housing objectives. And then for project proponents, reduced CEQA documentation will significantly shorten processing times, reduce approval periods from years to months. I think limited environmental review will also translate into savings on costs and administrative expenses. It could increase your design flexibility for applicants by really optimizing projects for housing production without, you know, being artificially constrained by some rigid exemption criteria. And then finally, I think this could potentially reduce the scope of challenges when you have a more narrow scope of environmental analysis, but I think that may have yet to be seen, as there may be some initial litigation to clarify parts of these laws that are a little unclear here. And then to put this into practice, there are several considerations for lead agencies here. I think you'll want to develop some standardized procedures for identifying and processing near-miss projects. You'll want to incorporate a screening process along with your preliminary review for CEQA exemptions. The same you would do as part of the determining whether your project is exempt, and then establish clear criteria for determining when conditions qualify as that single condition. If you have your own CEQA guidelines, which every city should, amend them to include these new provisions. I know a lot of local lead agencies primarily rely on the state guidelines, but you'll want to make those updates. Create templates for limited environmental review documentation and determine what that might look like. You want to document conformance with all other exemption criteria. So again, if it's just that one near miss criteria, that single condition, document your conformance with all the others first before you move on to the limited environmental review for that single condition. You'll want to work with applicants in pre-filing consultation. So this law does allow for and encourages pre-filing in order to identify some potential near-miss opportunities and clarify the scope and requirements of the analysis. And where appropriate, you'll want to prepare focused technical studies that do address some of the specific disqualifying conditions. So either as a lead agency, you may need to hire some consultants or request the applicant provide those as part of their application process. And of course, you'll want to coordinate with legal counsel on interpretation of these guidelines, as we are not providing legal advice here. And I think I'd just like to close here by suggesting that SB 131 near-miss provisions can also work in tandem with AB 130, which we just talked about. So projects that don't qualify for AB 130's new exemptions may still benefit from the limited environmental review process if you miss one of those single conditions, and you can eliminate the analysis of alternatives and cumulative impacts in that focus review.
All right, thank you, Chad. I see one question from earlier in the presentation. I think we pretty directly answered that. It was a question about what happens if for a near miss, if related to a criteria for the exemption, the urban infill exemption. What does the documentation look like in a near miss study? I think you've done your best to provide some guidance there, Chad, in light of the uncertainties you noted there. So hopefully we answered that to the person who asked the question. If you have any other clarifying questions or want to dive into the details, welcome additional questions and discussion on that topic. But I'm going to mark that answered for now, because I think we hit that one pretty square. All right. I think we'll save the other question for the next portion of the presentation still. And I don't see any others, so I think we can keep moving into the next section. And I think, is this you again, Gabrielle?
Yes.
All right.
Okay, so in this portion of the presentation, we'll cover the rest of the CEQA exemptions that were in these bills. We will be staying at a pretty high level just because there's a lot of them. So the housing element rezoning exemption is an exemption. It exempts from CEQA review the rezoning that implements the schedule of action in an approved housing element. This typically is the rezoning of sites to increase density to meet the regional housing needs allocation goals. The exemption does not apply to certain types of rezoning, such as if the rezoning would allow for construction of a distribution center or oil and gas infrastructure, if the rezoning could allow construction to occur within the boundaries of natural and protected lands, and then also if the rezoning could still qualify for the exemption if it excludes portions of a site that have the natural and protected lands. And those could be rezoned at a future time following other CEQA procedures. Next slide, please. So we have some categories of other exemptions that are in these bills, and we are not going to go into any detail. But we have large-scale infrastructure and manufacturing exemptions under this category. There are 3 specific exemptions. One is related to advanced manufacturing facilities and sites zoned for industrial use. One for certain projects that are related to high-speed rail, and another for broadband in the public right-of-way. Under the public health and community spaces category of exemptions, there are exemptions for rural health clinics, federally qualified health centers, nonprofit food banks and pantries, daycare centers in non-residential areas, and certain public parks and non-motorized trails. And lastly, under the environmental and agricultural exemption category, are certain community water and sewer service projects, updates to state climate adaptation strategy, certain wildfire risk reduction projects, and certain agricultural employee housing projects. Next slide. Some other CEQA changes to touch on are revisions to what is required to be included in an administrative record. This comes into the context of CEQA litigation, so I don't know how often you all will be involved in this, but in particular, interagency emails that were not presented to the decision maker and a few other things related to that do not need to be included in the administrative records. So that will save a lot of time gathering these types of records, as well as if someone were to print the administrative record, a lot of pages. A couple other topics are infill guidance is to be updated every 2 years, starting January 1st of 2027. And then in these bills, there was a little oversight in that AB 130 and SB 131 both included provisions with the same Public Resources Code section. Under statutory interpretation, the bill that was adopted last is the one that prevails, and those are the laws that go into effect. So there is an open question about new VMT mitigation provisions, as these were in the bill that was adopted first. I think this is an open question, and we'll see what the legislature does. Typically in bills, if there is an intention to negate one of the provisions, it will say something to that effect in the bill, and these bills did not do that. Okay, I think that's it for the CEQA. And I'll now touch up on some of the housing law updates. Again, this will be a pretty high-level summary. So the next slide, the Permit Streamlining Act had a few revisions made to it. To start, the definition of a development project is any project undertaken for the purposes of development, including permit for construction or reconstruction, but does not include any ministerial projects. And this is where AB 130 makes a modification. The ministerial projects for housing development projects now fall into this definition and now fall under the Permit Streamlining Act. The Permit Streamlining Act still does not include post-entitlement permits. So what this means is there are some new timelines for ministerial housing projects. The ministerial project must be approved or disapproved within 60 days of a complete application. Also added to the Permit Streamlining Act is the timing for the CEQA infill exemption, which Barbara talked about earlier in the presentation. This is specifically in the Permit Streamlining Act now. And then lastly, we wanted to touch on the interplay with SB 35 processing. This gets pretty tricky and can be a little bit confusing. SB 35 has specific processing timeline provisions in the bill, so we need to be layering those provisions with the Permit Streamlining Act provisions of timing. So in particular, under the initial review, so when you first receive the application, there is 30 days to determine whether that application is complete. If the application is complete, for projects that are equal to or less than 150 units, there's an additional 30 days for consistency review and then 30 days to make that decision. And this falls within that 60-day approve or disapprove. For projects that are greater than 150 days, the consistency and decision must be made within 60 days after completeness. If the application is considered to not be complete, for projects that are less than or equal to 150 units, there's 30 days to determine consistency. And for projects greater than 150 units, 60 days to determine consistency. Upon resubmittal of an application, There's 30 days to determine completeness and consistency. And if complete, the application, or I'm sorry, there are 30 days to make a decision on the application. So as you can see, that these timelines can get pretty tricky when we're combining these different statutes. So that's all I'm going to talk about on the SB 35 processing. Some other housing law updates are related to homeless shelters. So there's a new inspection and reporting requirement. This imposes new requirements on cities and counties to perform annual inspections of every homeless shelter in their jurisdiction to ensure that they are in compliance with laws. Cities with population that are under 100,000 people may partner with their county to conduct the inspection. Additionally, cities and counties must report to HCD the number of complaints that have been received, even if that number is 0. And HCD may withhold state funds from a city or county that fails to comply with the reporting requirement. There is also some new posting of information requirement. Homeless shelters must display information about an occupant's rights and the process for reporting a complaint alleging the homeless shelter is substandard. Additionally, contact information must also be posted for the shelter's owner, the shelter's operator, the city or county, and HCD. And this information must also be provided upon entry into the shelter for a new occupant. Next are related to residential building codes. There is both a statewide and local freeze on building standards for residential units. This goes until 2031. At the state level, building standards will not be updated on the 18-month cycle. And at the local level, cities and counties cannot make or establish more restrictive building standards for residential units. There are some exceptions to this freeze, and that's the California Building Standards Commission can deem a change necessary as an emergency standard to protect health and safety. Building standards that are amendments by the state fire marshal to building standards within the California Wild Urban Interface Code could also be adopted. And then there's a few others that are specifically listed in the statute. Moving on to model homes. So state and local building standards that are in effect at the time of the building permit application for the model home in a home, a housing development complex. Those standards will apply to future residential dwellings that are based on that model. Exceptions to this are if the design substantially changes or if 10 years have passed since that model home building permit. And then lastly on this slide are restrictions related to Coastal Commission appeals. So this is a very limited exemption. There are 2 types of appeals that now do not apply to residential development projects. A residential development project is defined as a multifamily project with 4 or more units. And these restrictions are for developments that are located in a sensitive coastal area and developments approved by a coastal county that are not in the principal permitted use. Appeals are still allowed for developments with fewer than 4 units. This includes a single family home, and appeals for residential development projects that are located between the sea and First Public Road or within 300 feet of high tide line, on tidelands, within 100 feet of wetlands, estuary, or stream, or within 300 feet of the top of the seaward face of a coastal bluff. So as you can see, it's pretty limited. Let's go to the next slide, please. So these bills also repealed a lot of the sunset provisions. Sunset provisions were in place saying that particular laws would expire on their own terms by a certain date. A lot of times, I believe this was around 2030, 2031. The provisions that are no longer expiring are the Housing Accountability Act, the Housing Crisis Act, the Permit Streamlining Act, the 5 hearing limitation application checklist requirements, and preliminary application requirements. Also, the Starter Home Revitalization Act. And this means these bills go on indefinitely, so it should not actually change anything in your day-to-day processing. Of course, the legislature can always come back and make amendments and changes, so you need to still be looking out for those types of changes. These bills also made some specific amendments to both the Affordable Housing on Faith and Higher Education Land Act and the Starter Home Revitalization Act. I will touch on these very briefly, but we're not going to go into detail of what these laws are. So the Affordable Housing and Faith and Higher Education Lands is a bill that went into effect last year, so it's still a fairly new law. In particular, there were previously requirements on the total number of parking for non-residential spaces on a site, and this requirement has been removed. Now the law states that previously legally permitted uses or religious institutional uses are included in the proposed development, and that provides 1 parking space per unit. So I think this leaves an open question on how much parking is required for previously existing use on these sites. Additionally, the maximum building height is 1 story or 11 feet above the maximum height. The 11 feet is what was added. And then also childcare ancillary uses were previously allowed, and now this bill specifies that there's no limitation on the number of children. Moving on to the Starter Home Revitalization Act. This is also a law that went into effect last year. In particular, the law allows for remainder parcels in the subdivision, which are not included in the 10 parcel limitation. And there are specific requirements to how those remainder parcels are to be treated. There's also new requirements for the sale, lease, or finance of parcels that are created through this process. And we're not going to go into any details. These things all get pretty complicated, as most of these new recent laws are. And then the last thing to touch on have to do with accessory dwelling units. Previous versions of ADU law had a provision that if a jurisdiction had adopted an ordinance prior to July 1 of 2018 to ministerially approve ADUs and multifamily dwelling structures, and these are what we now call the state exempt ADUs, the local jurisdiction could impose their own objective standards rather than being limited to what was in state law. This provision has been removed. So if your jurisdiction had objective standards for multifamily ADUs in place prior to July 1, 2018, you can no longer apply those to those particular types of ADUs. And now you can only apply the objective standards that are allowed under state law. Okay, moving on to the next slide. And this will be our last topic. If we could go to the next slide, please. Thank you. This will be the last topic that we're discussing in our presentation, so there will be plenty of time for questions. Previously scheduled revisions, well, this is still law. So prior to the scheduled revision of housing elements, the Council of Governments, in consultation with HCD, must propose a methodology for distributing the existing and projected regional housing needs for cities and counties within that region. HCD must review the draft allocation methodology and report its findings to the Council of Government. Previously, if HCD determined that the methodology was not consistent with the state law, the Council of Government could either adopt a revised methodology, or it could adopt the previous methodology that HCD found inconsistent if it made particular findings describing why it thought it complies with state law. So that has now been changed. The rule now specifies that if the methodology is found to be inconsistent, the Council of Government must, in consultation with HCD, revise the methodology within 45 days. After receiving HCD's acceptance, the Council of Governments can adopt the final regional housing need allocation methodology. So how this impacts the San Diego region is that in 2019, AB 1730 was passed, and this realigned the RHNA timelines with the regional plan. Housing elements in the SANDAG region are due 18 months after the adoption of the 2029 regional plan. And SANDAG expects to conduct its consultation with HCD in late 2027 and early 2028. And that makes it so housing elements would be due in mid-2031. I think more specific details on that will come out closer to those times. And I believe that is all that we have related to AB 130 and SB 131. So Matt, I'll turn it back to you.
That's all we've got. Yeah, that was a lot of information. Thank you, Gabrielle, Barbara, and Chad for helping to walk us through that and try to make some sense of it. It is all very complicated and interacts with each other in different parts of these changes. I am going to start with one of the questions we've tabled. We finally got to the section on housing element rezones, and we've got a question that if a city adopts a rezone program without an EIR, would that potentially hamper the ability of someone to use section 15183 because of the land uses were not adopted via an EIR as required in 15183 D2? So how might that work? Does anyone want to take a shot at answering that?
I was taking a look at this question, and I think it's a little nuanced because 15183 says that the project must be consistent with the zoning or general plan for which an EIR has been certified. So I suppose if it's consistent with the general plan and not the zoning, it could potentially be used. But it also needs to be consistent with the development density, and you would probably need to address whether there's anything peculiar or different from what was in the general plan. But I think that one's a little complicated. I don't know, Barb or Gabriella, do you have any thoughts on that?
Yeah, I mean, the issue about being peculiar is whether it's I think you could use it for the zoning, and you'd look at whether it's whether there are new impacts that weren't considered in the but we're assuming that that the zoning was exempt, right? I think that really creates problems for using 15183. If there's no general, all these 15183 requires that there be an EIR at some phase, the general plan, the zoning, or the community plan. And without those in any phase, I don't know exactly how you could use it. I mean, you have to make findings that it's consistent with the mitigation measures. So I think that might be problematic.
So what other options might there be on the table for reviewing subsequent projects if a city uses the housing element rezone exemption here?
Well, they could try to use the infill exemption, right?
That's what I was just going to suggest as well.
I mean, that's much easier, frankly. As Chad said, 15183 has been used a lot, but it requires extensive documentation, whereas the infill exemption is much easier.
All right, thank you. I think we've answered that one sufficiently. Appreciate the discussion and thought. We have another question on ADUs. Can owner occupancy requirements still be used if a city is providing a loan with a covenant to construct an ADU for low or moderate income households?
Barb, I think I'm going to ask you to jump in because I know you've been working on this a lot more closely, but HCD has opined that you cannot place a restriction on an ADU. I mean, I understand that the loan would be for a different purpose than the actual ADU. So I don't know how HCD would feel about that particular scenario.
I think if the city is providing a loan with a condition, because the unit is affordable, I think in that situation, the city could apply a covenant. In all, just for the pure approval of an ADU, HCD does not allow a covenant, but for But if the city's providing a loan, that's a different situation. Because nothing requires the city to provide the loan, right?
Nothing's preventing the owner from doing the ADU without
Without
the
the
loan. They still
loan.
have the ability to
Exactly.
build.
Right. Nothing requires them. Only getting money from the city or the county requires them to make the unit affordable.
All right. Well, thank you. And if whoever asked that has any follow-up questions, let us know. That's all the questions we have in the Q&A for now. If anyone has any other questions, we still have some time left in our presentation. I'll give some time here for additional questions through the Q&A. I'm not sure exactly how our Zoom settings work, if you can raise your hand to ask questions or not, if that's an option. But if that's an easier way to ask a question, we might be able to figure that out here on the fly. But so far, seeing nothing. So we just got a question about public improvements in a housing project. It was noted that they are exempt. If a grading permit is discretionary, would the bills now render the grading permit exempt?
Yes, because it says not only public improvements, but related permits. That's the language in the statute. It states, hang on, I'll get the exact language. It says the housing development project, including any permits, approvals, or public improvements required for the housing development project, are included in the exemption. So the grading permit would also be exempt.
Thank you, Barbara. All right. I'm going to ask a question here about the rezone exemption and how it might work for 6 cycle housing elements. Could a city, in theory, use it to meet their RHNA shortfall? How might that work? I think we talked about subsequent projects, but is there any documentation that might be required for the housing element rezone exemption? Yeah, and how should jurisdictions proceed in that case?
Yeah, I think what a jurisdiction would want to show is that it's part of the implementation program in the housing element, and that's why you can rely on that particular exemption. I think if there is a housing shortfall in your rezoning in that case, I think that would be the way to go about it.
Yeah, in addition, if it's no net loss, if the additional rezoning needs to be done for no net loss, most communities have some kind of a program saying that if they need to, they'll need to do the rezoning for no net loss. So long as a housing element has a program like that, it seems that that exemption would apply to that rezoning as well.
What if is not a program in your housing element, but it is required to stay compliant with government code?
Well, then you'd have to do it, but I'm not sure that the exemption would apply.
Okay.
Yeah.
And what about 7th cycle? How might jurisdictions think about the housing element rezone as they prepare for the 7th cycle housing element? What might this change? How might cities and counties strategically use this exemption as they start to think about capacity for future RHNA cycles?
Yeah, I think the future, the 7th cycle housing element will need to, to make sure to be clear that you have language in there for that rezoning so that you can rely on the exemption. I don't think the exemption would apply to the housing element itself, so you may still need to do some other analysis for that housing element. And then also going back to the earlier question of applying 15183 that could be an opportunity to allow that streamlining by doing an actual EIR on the housing element, if that makes sense for that, that particular housing element.
Some jurisdictions in the sixth cycle didn't do an EIR in any case on the housing element itself, saying that there were a variety of rezoning options that they were considering, and so it was too early. But I don't think that will be possible in that they would do CEQA when they did the rezonings. So that probably will put more pressure on doing CEQA on the housing element. By the way, there's an important case people might want to follow at the First District Court of Appeal. It's Committee for Tiburon versus Town of Tiburon. And it has to do with a group of very wealthy neighbors who argue that that the town should have done a more detailed site-specific analysis of the housing element in their EIR because this particular group of wealthy neighbors submitted a lot of evidence about the site. And the Attorney General has written an amicus brief saying, to the court, if you uphold the lower court's decision, which decided the city did have to do more review, you'll be making it impossible for cities to get their housing elements approved. So it's going to be an important case. I'm sure it'll be published, but you might want to, again, follow it. It's called Committee for Tiburon versus Town of Tiburon.
Thank you for the heads up on that one. I'm going to ask another question about the urban infill exemption. If a project is potentially eligible for Class 32 categorical exemption and the new urban infill exemption, how would a jurisdiction decide which pathway is best?
I think oh, go on.
Oh, go ahead, Barb.
I was just going to say, I think you'd want to consult with the applicant. And look at the findings. Some applicants may not want to use the new infill exemption, one, because of the prevailing wage requirements for the higher buildings, and secondly, some may not want to go through the tribal consultation, particularly if they're all set to be approved with an infill exemption. But Chad, feel free to add. Sorry.
Well, I was just gonna talk about, I think as far as, I don't know how you feel about this, Barb, but it seems that it may be legally more defensible to use the statutory exemption, maybe subject to fewer legal challenges, but.
Yeah, I think it depends on the particular project, right? I do have a number of working with cities on a number of projects where the applicants don't want to use the new exemption because their buildings are more than 85 feet high. So that's one. And then I think in terms of using, developers who, for whatever reason, don't want to use the tribal, don't want to go through tribal consultation, I think it would depend on how controversial the project is, and its its ability to be challenged under the infill exemption.
Yeah, so I think this comes down to, it's a case-by-case, project-by-project analysis as to which of the two exemptions might be a better fit for the project.
Yeah.
And similarly, a similar question on the near miss provisions. How risky is it to use those in, your opinion? What's the standard of review, and how easy is it for people to challenge the documentation?
I don't think we know yet.
Yeah, it's determined.
I think there's a lot of, like I said, that when I was speaking, I think there's a lot of questions still about how that will be used. And I think some of that's going to have to be decided in the courts, unfortunately.
Okay, we will see. Chad, you talked about the urban infill exemption as a fundamental departure. I think generally it sounded like you were optimistic about its potential impact and benefits and ease of use all around a helpful tool. Did I characterize your opinion on the effectiveness of this exemption correctly? Do you and this kind of goes to all of you. Are these going to be impactful? Is the exemption really where there's going to be the most change and potential benefit? Or what else might be helpful out of this, in your opinion?
I think the AB 130, combined with the near miss is gonna make a lot more projects qualify for exemptions, because there were a lot of projects that that it's sort of like an all or nothing approach, right? And so I think by opening that up, expanding the site area, reducing the amount of documentation and the amount of criteria, I think it will greatly expand the use of this exemption. But I do think you still need to document. You can't just do like a naked checklist like they used to have for additional studies. You need to provide the evidence, the supporting evidence, and that may require some additional studies. But I do think more projects will be able to qualify for exemptions than previously.
All right, thank you. We've got a couple questions in the chat. I'm going to read this one out. If there is a near miss scenario which requires the preparation of a negative declaration or an EIR, the lead agency would have to do AB 52 consultation. If tribal cultural resources was not identified as the issue causing the near miss, but through AB 52 consultation, the tribes identify a potential impact to tribal cultural resources, would you need to do a standard EIR at that point? In other words, would you need to analyze alternatives and growth-inducing impacts?
That's a good question. I'm not sure I have an answer off the top of my head without having spent time looking more closely at each of these statutes. Barb, I don't know if you have thoughts.
Yeah, that's we don't really exactly know the answer to this, but let's say that the near miss was due to a biological impact. I'm just making something up. It seems that the EIR or whatever documentation is done needs to be limited to the biological impact, and that the tribal consultation could be dealt with through conditions of approval, but it probably doesn't require additional environmental review, if that makes sense. Because the environmental review is supposed to be limited to the biological impacts. So unless the tribal consultation reveals another impact, so that now you have two impacts. But if, let's say for the infill exemption, it's not well, let's see, what's a better example? Let's say for the infill exemption, it's located within 100 feet of a wetland in the coastal zone. So you look at that impact. The fact that there might be a tribal impact, the tribal impacts aren't an element in the infill exemption. So it would seem that the EIR or whatever documentation you're doing would be limited to the wetland impact, but you do need to pay attention to what the tribes want. And again, I would suggest by conditions of approval, but it's very unclear.
I don't think it would hurt to add a tribal cultural resource section to your focus analysis though either. Like,
yeah,
even if you're focused, I would just be clear that based on this provision, you're analyzing this one condition, but because of the tribal consultation process, you're adding this additional analysis and potentially mitigation.
Yeah, that may be a safer approach.
All right, thank you for that response. Gabrielle, this one might be for you here. Can you elaborate further on the chaptering issue and oversight between the two bills regarding VMT requirements?
Yes. So typically what we see in the normal process for bills is you will have potentially more than one bill that covers a particular topic or a particular statute. And when that happens, when we get to the very bottom of the bill, there will be language saying, if this bill is adopted first, these provisions go into effect and these provisions do not. AB 131 and SB 130, unless I flip those, did not have that particular statutory language. So then we look back at how this is typically done, and I believe there's I forget which section of law it is, maybe government code or civil code, perhaps. I think government code. That then tells you what to do, and that is when the bill is adopted last, we assume that the legislature did it on purpose, and that therefore that's the law that they want to go into effect, not the one that was in the earlier adopted bill. But this just leads to a lot of confusion because the budget trailer bill process is a little different than how most bills are adopted and enacted. So that's why I think it's an open question. It seems like the legislature intended for both of these laws to go into effect. They just perhaps had a misnumbering issue where they provided the same statute number to two different legal provisions. So we'll see if there are any cleanup actions that come through over the next few months.
Oh,
Are you going to take the next one here, Barb?
well,
Does
I did a presentation for city attorneys, and somebody asked the same question, and the answer is no. The question is, does AB 130 define or has the state offered any guidance as to what constitutes a substantial change with respect to the model home standards vesting? And so the building code provisions used in the model home are to be used throughout the project unless there's a substantial change in the design of the homes. And there's no guidance right now about what constitutes a substantial change.
All right, thanks for taking that one on. Gabrielle, going back to the VMT question, I'm trying to research here to understand what the ideas and requirements in each of the bills that are actually in conflict were. I know AB 130 had some language, I think, about VMT mitigation banks. I'm not sure what was in SB 131, if they were similar in nature.
Not at all. So yes, it had to do with VMT mitigation banks. And then what was in the other bill is one of these categories of exemptions that were listed on the slide. So completely unrelated to VMT.
And they just happened to reference the same section and stepped on each other's toes.
Exactly. So I think that's why there's a little bit of open-ended questions and confusions because the two statutes are not related to each other.
Gotcha. All right. I think that helps with that. All right. Any other questions at this point? I'm not seeing any. Maybe we can move towards wrapping up and see if anyone has any last questions before we sign off. But just as some reminders before we conclude our webinar, our team, our technical assistance team, including Goldfarb and Littman, Chad, and other subject matter experts we have available on our team. We can provide additional assistance on these topics and anything else housing related that you may need assistance with directly one-on-one through the SANDAG HAP Local Staffing Assistance Program. If you have additional questions or want additional assistance, please just reach out via email to housing@sandag.org. We can try and answer your question via email or set up a time to discuss any issues you may have that way as well. So I also want to note we are anticipating an additional call for local staffing assistance requests beyond AB 130 and SB 131. So think about any outstanding items you may have in your housing element programs or other way we can assist with that. As we noted in the beginning of the presentation, these were urgency measures adopted as part of the budget process, but the legislative cycle is still ongoing. There are still housing-related bills making their way through the legislative process. We are continuing to track those other bills, and we will update our legislative tracker on the bills of interest once they finally get passed and see what gets signed. So that will be in mid-October after the deadline for the governor to sign any bills passes. We do anticipate another webinar at the end of the year to provide updates on any legislation that we are tracking and help answer your questions around that as well. And then further, we are anticipating and planning for a webinar around current planning and housing approvals, expediting and streamlining generally housing, but also with some focus on affordable housing and perhaps bringing CEQA into the conversation as well. There is a question about, is there a way we can track legislation bills? We will be doing some of that for you. So as I mentioned, keep an eye out for that. I'd also encourage you all to get familiar with the legislative website. You can do individual bill tracking there if there are specific bills that you're interested in and we really want to track closely. So that's kind of the central repository that publishes updates and current versions of bills. I just put that in the chat. And then, yes, this webinar will be available. A recording of it will be available, as well as the presentation slides for your reference and review in the future. So I think that's it on upcoming TA. You all are here, so obviously you got the information somehow, but if someone forwarded it to you and you are not signed up for email updates from the SANDAG housing team, please sign up for that, and we'll let you know when future webinars are scheduled and any other technical assistance resources are published. So the link is there, and I don't know if we put that into the chat, but hopefully we can do that so you don't have to try and jot down all the characters on that link. As always, check out the project website for SANDAG for all the latest resources. If you have any questions, local staffing assistance, or otherwise about the HAP TA program, email housing@sandag.org, and you can also contact Carrie directly by email or phone. So I think that's it for us today. I don't see any other questions. Carrie, anything else you would like to say before we wrap up?
Nope. Thank you to everybody presenting and for everyone joining today. That's it.
We'll leave it at that. Thank you, everyone.